Hi, John Hayes again. I'm going to talk a little bit more about exemptions in bankruptcy. So for this video, I want to focus on the homestead exemption. In California, where I live and practice, the homestead exemption beginning on January 1st of 2021 is $300,000 minimum and $600,000 maximum. How do you know whether it's where you are? It depends on the county that you live in and the median sales price of homes in the county where you live in. So in Los Angeles, where I live and practice, the median sale price is more than $600,000. So the exemption, the homestead exemption in Los Angeles is $600,000 as of January 1st, 2021. So what does it mean, your homestead? The definition again is in the California Code of Civil Procedure and in the 704 section of the exemptions. And what it says is you have to live there. But what it says is that it's a dwelling. And the dwelling can be a home, could be a boat, could be a condominium, an RV, I guess, for that matter. It's your dwelling. All right. And I mentioned you have to live there on the date you filed. There are a few exceptions to that. I mean, if you're away temporarily, you're in the hospital on the day you file your case, you're on vacation. I had a client once that he was renting out the house in monthly installments. And I mean, we didn't have any trouble with that. He happened, there was a tenant in the house the day he filed, but it was a 1-month lease. The guy moved out, my client moved back in. There was a case a couple of years ago in California where the debtor was actually living with his mother at the time he filed because he needed health care. He had been in the hospital. When he got out of the hospital, he went to live with his mother, who was just apparently down the street. And so he was actually living with his mother. And the court said still that's his dwelling because he intended to return to it. All right, so it's $600,000. There's a couple of things to worry about, and that's what lawyers do, is we worry. One thing is the $600,000 is limited to 100 or 300, whatever the number is. It's limited to 170,000 unless you've lived in the house more than 3.3 years, 3 1/3 years. Where did that come from? I don't know. The code says 1,215 days. I don't know where that number came from, but if you have lived in the house less than 1,215 days on the day you file bankruptcy, then the maximum exemption is 170,000. All right. I should mention once again, just in case you haven't listened to my other videos, what exemption means is it's the equity that's protected. It's not actually the house that's protected, it's the equity. You're protected from the trustee. The trustee, if the trustee were to sell the house, he would have to pay the mortgage. And the second and third, if you have other mortgages, and give you enough for the homestead exemption, and then he can keep the rest. Well, if there isn't anything left, then he can't sell the house. and the house would be abandoned. In other words, in the bankruptcy case, the trustee would ignore your home. Why? Because the exemption is protecting all of the equity. All right, what happens if you sell? I have some notes here. What happens if you sell the house before you file? You take the proceeds, let's say you get $500,000 of proceeds. You owned it for 10 years. You sell it, and you have $500,000 of proceeds. You put that into a bank. You file bankruptcy. Are the proceeds exempt? Well, you didn't live in the house on the day you filed, so you don't get the homestead exemption. But under California law, the proceeds are exempt, but only for 6 months. If you take the proceeds within the 6 months and put them into a new home, the home is exempt again because it's of the homestead exemption. So the proceeds of the sale are exempt, but only for 6 months from the date the homeowner received the proceeds. All right. What if it's sold after the bankruptcy? Well, remember that your debts are wiped out. Once you file Chapter 7, you don't have any more debts. So theoretically, you don't have any creditors to worry about after you file. But if for some reason the house is sold during the Chapter 7 case, and you, the homeowner, receive some of the proceeds because of the homestead exemption, those proceeds, again, are exempt, but only for 6 months. So it's actually something to worry about. If the trustee can keep the case open to see whether or not you put the proceeds into a new house. So let's say the trustee abandons the house 2 months into the Chapter 7 case. Right after that, you sell it. And there's $600,000 of equity. You receive $600,000 in proceeds from the sale of the house. Those proceeds are exempt, but only for 6 months. The trustee, I guarantee you, will keep the case open, the bankruptcy case open for 6 months. And if you haven't used those proceeds, in other words, if you still have them, you haven't used the proceeds to buy a new house, the trustee will demand those back. That comes from a case called Jacobson in the Ninth Circuit. In re Jacobson. I really would love to appeal that case. I've actually been looking for some case where I can attack the ruling in Jacobson. I don't think there's any doubt that it's wrong, but it's the law in the Ninth Circuit. Bankruptcy judges are bound by the findings of Jacobson in the Ninth Circuit. So if you sell your house, or if the trustee sells it for that matter, maybe there's more equity than the homestead exemption. If there's $800,000 of equity, the trustee will sell your house. He'll give you $600,000 and he'll keep $200,000. The Jacobson case says that $600,000 that he gives you is exempt, but only for 6 months. If within 6 months after that you haven't sold the house, the trustee can grab that money. All right. One last thing on the homestead exemption, I think, is judgment liens. And I've actually been thinking for a while how I'm going to explain this without having a chart, without having a blackboard that I can write a bunch of numbers on. But so let's try to think of it simply. There's one of the basic rules of bankruptcy is liens don't go away in bankruptcy. Debts are discharged. Liens are things that attach to property. Liens don't go away in bankruptcy. So if your house is worth $500,000 and you have a mortgage of $400,000, you have $100,000 of equity. that 100,000 is exempt if you file bankruptcy. The trustee will ignore your house. All right. But what if American Express sued you and got a judgment for $100,000? Now you have a first of 400 and a second, really, a judgment lien that attaches to the house of 100. So you have a house worth 500, but you owe 500. Trustee will ignore it. There's nothing that the trustee can get. But it's really kind of unfair that American Express is going to get paid in full, really, out of your homestead exemption. You know, the exemptions were designed to protect you from your unsecured creditors. Now it's doing the opposite. American Express got a judgment lien. They're going to get paid in full out of something that would be normally exempt. So the bankruptcy code says in section 522F, as in Frank, that the debtor, the person that filed bankruptcy, can avoid, in other words, wipe out the lien or strip off the lien, strip the lien off the house, make the lien go away. The debt's already going away. You're getting the discharge. You can get rid of the lien also because it is impairing, that's the magic word, impairing your exemption. All right, you file a form in the Central District of California. It's a pre-printed check the box form. You say, court, look, here's how much it's worth, 500,000. I already owe 400 on my mortgage. I have the right to exempt the rest of $100,000. But I'm not going to get my exemption because this judgment lien is using up the space, you know, the equity in the house that would otherwise be exempt. And those motions are routinely granted. I mean, that's what the code says. The American Express could say, no, your house is worth more. But if the house is worth what I said, 500, and the first is 400, that motion is going to get granted. So the debt is wiped out and the lien is wiped off the property. So a couple other things about that quickly. Thing one is it's not that unusual that the debtor doesn't do that. The lawyer doesn't do it. Maybe you didn't know American Express had a lien. So 3 years later, you're trying to refinance the house, and the bank who's going to loan you more money, they find out American Express has that lien. Liens don't go away in bankruptcy. You can reopen your case. The courts are very casual about allowing you to reopen your case and file the forms, wipe out the lien. It doesn't matter that the house has gone up in value since you filed. The numbers, the value of the house, the amount you owed on the date you filed, and the amount of exemption is determined as of the date you filed, even if you're trying to remove the exemption 5 years later. All right. One other thing is you have to do the math sometimes, because if there's more equity than there is homestead exemption. So in other words, the homestead exemption isn't protecting 100% of the equity. The lien, the judgment lien, that is impairing the homestead exemption will not be wiped out entirely. Because there's a little value in that house beyond the homestead exemption, the lien that American Express has that attaches to the house is actually attaching still to that little bit of value. Maybe it's a lot of value. Maybe if your house is $5 million or something, maybe the lien won't go away at all, except to the extent of the homestead exemption. So when the dust settles, you make the 522F motion. It guarantees that someday when you sell the house, you will get at least the amount of the exemption that you were entitled to on the day the case was filed. So that's 5 videos on exemptions. Unless I think of something later, I'm going to leave it at that. I'm a partner at the firm of Resnick Hayes Marati. Our website is rhmfirm.com. If you like the video, click like. If you have any questions or comments, leave them on the YouTube comment section. And I do read those. I try to get back to you. And so thanks a lot. Have a good day.